May I please, Your Lordship? I beg to mention item number 15.
Item number
15, Lordship. That this matter must become after 1 week.
appeal
Yes, Lordship.
on pre-made by the appellant seeking adjournment. This is matter up to 2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 14. Your Lordship, I'm praying for 1 week time, Your Lordship.
Oh, 222 matter on pre-made by the appellant. This is matter up to 2 weeks.
God bless you, Lordship.
Please, Lordship. I beg to make a mention for item 8 and 10, Your Lordship. Lordship, the conducting causes have some difficulties, Lordship, today. So may we fix tomorrow, Lordship.
I think we have agreed this matter is
Yes, Lordship, but
fixed
Mr.
item
Paul
today.
is having some difficulties, Lordship, today. So maybe I paid the matter fix tomorrow, Lordship.
9 also. 9 is different matter, no?
8 and 10.
7 and 8 it should be.
You are for
I'm from petitioner, Lordship.
petitioner on pre-made by the petitioner. This is matter tomorrow.
Lordship, a similar prayer for item 10.
You are for
I'm from petitioner, Lordship.
so an old matter 2019.
Fix it tomorrow, Lordship.
Have you sought the consent of the respondent?
We'll be informing, Lordship, the parties, Lordship. If not here around.
On pre-made by the petitioner. This is matter to 1 week.
We are blessed, Lordship.
Your Lordship, I beg to mention item number 13, Your Lordship.
My Lord, on the last occasion, this matter has come on Thursday last occasion, a week before. Then my Lord has directed if the party can come to a settlement because the amount has come down a little low, my Lord. That is the MCL matter, my Lord. The compensation bill.
Oh, that
My Lord, yes. But when the matter came the subsequent day, I make a submission that we have conducted all the procedure as per the point, my Lord, clause 10. So, my Lord, the documents were not present with me, therefore I sought for time. My Lord, I have received the documents, but my Lord, I couldn't file the affidavit on reason that Lordship has not given me the liberty, my Lord, as per the last order. Lordship has only directed the
let
matter.
the matter come up. We'll see.
So, my Lord, Mr. Philemon is on bereavement today. So, he has also informed me. But the materials have already come.
His colleague is here. If steps are to be taken from your side,
My Lord,
then you can do it.
I'll produce the documents. Is it okay?
So let her see.
My Lord,
Let the matter come up and a formal order will be passed, allowing you to take steps.
my Lord, let the matter be contempt.
Daily cost list, item number 1.
May it please your Lordship. Lordship, the matter has been endorsed to Madam N.G. Shilla, Senior Government Advocate. However, her son is not keeping well. So she's praying if the matter may be may come up tomorrow, Lordship.
At the outset, the request is made on behalf of the learned senior GA, who is said to be indisposed for the day on grounds of personal difficulty. The petitioner not objecting to the same, matters adjourned. This is the same tomorrow.
Highly obliged.
Obliged.
Item number 3.
This is the bail matter, my lord. We are seeking a bail in an NDPS case, my lord, on the ground of medical issues, my lord. This gentleman is now in hospital. In fact, my lord, in an earlier case, my lord, in one of the cases, the quantity in respect of his intermediate quantity, my lord. And in one of the cases, my lord was pleased to grant a bail to a similar situated accused person, my lord. The only ground, in fact, the ground which we are seeking to agitate here is medical ground, my lord. He is in hospital for quite some time.
What is his, what is the nature of his
Well, we are not really sure about what happened to him because the family members have not been allowed to meet him.
Where is he?
He's in civil hospital now.
So we'll get a report then.
Kindly, my lord.
At the outset, before proceeding with the matter, the learned counsel for the petitioner has submitted that the only ground urged upon by the petitioner herein is for grant of bail on the ground that the accused is he the petitioner himself,
Yes, my lord.
on the ground that the petitioner, accused petitioner, is sick and is undergoing treatment at the civil hospital. The family members would, however, like to refer him to a better facility, refer him to another private facility, hence the petition. However, Mr. Ensinkon Leonard G, appearing for the respondent, would submit that the latest medical report would be necessary to understand the nature of the ailment of the petitioner, accused petitioner. It's checked. Accordingly, without going to the merits of the matter at this juncture, the medical report, the prosecution is directed to produce the latest medical status in the form of a report as far as the petitioner case is concerned. This matter relates to
Nongpo PS, Nongpo PS case number 31.
31-3 of 23, my lord.
relates to Shri Ajay Thapa, accused person in connection with Nongpo PS case number
31-3.
Accused is Vijay Thapa, no?
of
Petitioner is the brother of.
Oh, I'm sorry, my lord. I stand corrected. I'm really sorry. But so the accused is Vijay Thapa.
Vijay Thapa. He's the
Sorry,
brother. Petitioner is the brother of the
Brother,
accused.
I'm sorry, my lord.
it's a change. Okay. So when do you get the report?
1 week, my lord. Next week, my lord, it can be listed.
Today is
Monday, my lord.
Today is 28th, my lord.
so next Monday would be 4th.
Yes, 4th.
Let's just matter on 4th.
Deeply honored.
Item number 4.
Yes, Your Lordship.
Yes.
May it please Your Lordship.
Yes.
Am I audible, Lordship?
Yes, yes. Mr. Datta, tell me.
Lordship, the accused persons are behind the bar today since 61 days, Lordship. And earlier also we have prayed on the length of detention, Lordship. And Lordship was directed the government side to produce the status report, Lordship.
61 days in custody. 61
Yes,
days.
Lordship. Behind the bar since 61 days in custody, Lordship.
Charge sheet file, Mr. Shankar?
My lord, not yet. My lord, there are other co-accused, my lord, who are yet to be arrested.
Then, whatever the case may be.
Yes. Not yet.
Makes it simple for this court. But then, what is this case about?
My lord,
Oh, that.
car lifting, my lord. This is where the truck was stolen.
But that truck has been, I mean, the vehicle has been recovered.
In one case, vehicle was recovered, and another case,
Vehicle has been recovered in Guwahati, Lordship.
In one case, and another case, my lord, vehicle is yet to be recovered. There is 25, 2023, my lord.
He has come here in connection with which case?
With two cases, my lord. One is Sela PS case 25.
Two cases are there, Lordship.
And another is 22/6.
One is Shela PS 22 and another is Shela PS number 20/05/23. That is in item number 6, Lordship. There are two cases, Lordship.
In both cases, charge affidavit filed.
No, my lord.
You see, whatever the case may be, you see, even, you know, I don't have to tell you the law. In fact, you should tell me. Even if there are some accused who are said to have absconded or are still absconding, you see, you can always proceed against those who are already in custody,
Right, my lord.
file the charge sheet, and then proceed with the matter.
From the report, it transpires that, my lord, no charge sheet is yet been filed. As far as 25/2023, if my lord goes through the status report, my lord, in this case, it does not appear to be these accused persons are not involved in this case as per because there is one person who is involved in stealing this vehicle as far as 25/2023. Whereas the other case, my lord, 22/6/2023, my lord, in this case, my lord, the vehicle was recovered from them only, and there are co-accused who are yet to be arrested in this case, my lord. Yes. They were initially arrested by the Assam police.
So there are, so as far as this case number 22 is concerned, they may be involved.
They are involved, my lord.
They are involved.
They are involved, and there are other accused also who are involved in this case who are yet to be arrested. Whereas 25/2023, my lord, if my lord goes to the report,
Page, have you marked it?
that is 25, my lord, that is 22/6, my lord, if that the one which I have flag marked.
Yeah.
The first one, my lord, that is 25/2000.
And 25 is the first part.
First one.
First part is 25.
Yes.
Or no, this is 25. Achha, there are
Two cases.
25, yes. 25.
Yeah, here, my lord, the accused does not seem to be involved in this case, my lord.
Okay. But he was shown arrest in this case.
Yes, yes, my lord.
Initially, he was arrested in connection with this 22.
22/6/2023, my lord.
Mr. Datta, you are NG Datta, NG.
MM Zaman Lordship. MM Zaman Lordship.
Why is the name appearing NJ Data?
Uh,
Case of mistaken identity.
Lordship Anjay Datta is also there, but he's in another legs in another court, Lord.
I'm very sorry because I can't expect to know each and every face associated with each and every name. Please come again, Mister.
Lordship.
Your name again?
M. Zaman, Lordship.
MM
My name is there in the cause list, Lordship.
Fine. Heard Mr. M. Zaman, Leonard Counsel for the petitioner. Also heard Mr. N. Sankon, Leonard GA. This matter has been put up before this court today. Pursuant to the order passed by this court on 25/8/2023, directing the prosecution to file the status report as regards Sheila PS case number 22/6 of 2023. It may, however, be noted that the accused person herein is also involved in another case, that is Sheila PS case number 2020/5 of 2023 under section 379. Both cases being similar in nature, in as much as it involves allegation of car theft. Brief facts of the case as far as case number 22/6 is concerned is that on 14/6/2023 an FIR was lodged with the in charge Bolaganj police. Is it police outpost? What's this PCP means?
Bolaganj police station.
Station.
Police station, yes. It is reflected like that. Bolaganj police station.
Is Bolaganj a police station? Sheila police station maybe, but I don't know. Where is the FIR?
Page number 11, Lordship.
11.
Bolaganj police station. Kunun to go. FIR was lodged. Wherein the informant therein said to be the owner of vehicle number ML10 C4160 has filed a report stating that her vehicle was found missing from the place it was parked. Accordingly, the said Sheila PS case number 22/6 was registered. The accused persons, namely, being suspected, being prime suspects in the case, were accordingly arrested and are still in judicial custody till date. for about 61 days from the date they were arrested. That is on, when were they arrested?
29 6 2023.
29/6/2023. The investigation into the case is still going on.
29/6.
Investigation into the case is still going on. However, it is admitted by the prosecution that the charge sheet, that the IO has yet to file the charge sheet, and accordingly the provisions of section 167(2) CRPC can be set into motion in as much as the said provision stipulates that in case
167 plus subsection 2 plus A2 Roman 2.
167(2), then
A
where is that? 2A, capital A, and
Roman 2.
where is the Roman 2? And the capital A, 2A, small a, Roman 2, which stipulates that, which reads as follows. I quote now. Without further discussion on this provision, needless to say that in a catena of judgment by this apex court, notably the case of, was it Rakesh Paul?
Yes.
2017 to SEC. It is clearly held that in case the charge sheet could not be filed within the stipulated and mandatory period of 60 days or 90 days, as the case may be, the accused person is entitled to be enlarged on default bail.
Rakesh Kumar Paul versus State of Assam.
Yes. ASEB, sorry, that was that Assam Public Service Commission case. By the apex court. Rakesh Kumar Paul. Citation again. It was held that if he is prepared to furnish bail Next, this being the case, at this juncture, the accused persons represented by the petitioner herein are entitled to be enlarged on bail.
Lordship, one small prayer, Lordship.
Yes. Tell me.
Lordship, the bailer, Lordship may allow the bailer from Assam also, Lordship. Otherwise, since the accused persons belongs to Assam, it would be difficult for them to find out any person in bailer in Meghalaya, Lordship.
I cannot. This court cannot specify as to who is to be the bailer. The only, what should I say?
Lordship.
More often than not, the court will insist on a solvent, surety. Whoever is solvent, if it is to the satisfaction of the trial court or the IO, they will be released. It doesn't matter.
Lordship,
It doesn't matter who.
Lordship.
Next, the above named accused person are hereby directed to be released on bail on the following condition: that they shall not abscond or tamper with the evidence and witnesses, that they shall not leave the jurisdiction of India without due permission, without prior permission from the IO or the court concerned, that they shall furnish personal bond of 1 lakh rupees with one solvent surety of like amount to the satisfaction of the IO or the court concerned. Next, needless to say, violation of the court's order or the violation of the bail conditions set in here and above would render the bail granted to be null and void in accordance with due procedure to be followed. In view of the above, this petition is hereby disposed of.
I'm deeply obliged, Doctor. I'm deeply obliged.
Just thank your stars that you got off on default.
Next matter also. Connected matter.
Same. So same order.
Same order.
Thank you.
Item number
vehicles, my lord. In both cases, two different vehicles is involved.
But you said in that
There was.
they may not be.
They were not found to be involved.
That is a question of investigation.
Right.
Charge sheet has not been filed.
Not yet.
Perhaps FR may be filed in any case.
Yes. Obliged.
Item number 7.
In this case, one respondent is yet to appear, my lord. We've taken steps against the respondent number 7. If anyone here is appearing for respondent number 7, we were directed to, my lord, take steps against respondent number 7.
Number 7 is the Darvashno?
Yes. To the extent, my lord, we have even taken a dasti as directed by.
Yes, you have all. The affidavit of service has been filed.
Yes, my lord.
Earlier they were represented.
They were, my lord. Madam.
They were represented by.
Sheila was appearing.
Okay, Miss Sheila.
Owing to her appointment engagement as a state counsel, my lord, she withdrew. So we were directed to take steps again. We had taken steps both ways, my lord, by way of postal service also and.
Is this a public forum, Mr. Kanta?
Mistake, I forgot that I'm online.
Yes, so what do we do? Tell me.
We'll wait for one more date, my lord, since you've served them a copy.
It's
Perhaps
an old, see,
it's an old matter, my lord, 2019 matter. Because if we proceed with this matter and they come on a later stage, perhaps everything will have to be redone. We can give them one more chance.
How important are they to the?
They are, my lord, because by the impugn order, my lord, our locality is sought to be merged with their locality.
Oh.
So at least, and in one of the occasions, they have given a categorical standing that we both stand on a different footing, and we do not. We are not similar. Rather, we are not similar, and therefore they have a separate jurisdiction whatsoever. They are, in a way, they were supporting my case, my lord. So I don't know what kind of stance they would put forward now. Keeping that in mind, my lord, they are also an important party in this matter, my lord. We can give them one more chance, just for the end of justice, my lord, and see if they don't come. At least my lord can record something.
Heard Mr. Estafa, the counsel for petitioner. This court, by order dated 11/8/2023, has noticed that the respondent number 7 has been duly informed, or rather duly issued with a notice to appear before this court as far as this matter is concerned. However, till date, the respondent number 7 has failed to appear before this court. It is the submission of Mr. Estafa, letter counsel for petitioner, that the presence of the said respondent number 7 is material to the issues raised in this petition, and as such, it would be prudent to allow the said respondent number 7 to be represented. It is therefore prayed that at this point of time the matter may be adjourned. All the other respondents are present.
6.
Upon hearing the land counsel for petitioner and the other respondents who are in attendance to this court today, the respondent number 7 is accorded another opportunity to appear before this court. The petitioner is requested to inform the respondent 7 of the pendency of this case. As prayed for, this is matter after 2 weeks. 2 weeks?
We'll inform verbally, madam.
Just inform verbally. Tell them that
We'll do
this.
that.
Item number 9.
Matter has been heard,
It's partly heard.
now forgotten. So ready?
Yeah. Lordship,
I think Mr. Bora, you have to again go through, from the beginning.
pardon me.
I think you have to go through from the beginning,
Oh yeah, Lordship, we'll start.
because I've forgotten what has been submitted.
Just to
This is with regard to those
This is the sawmill.
those overhead
Overhead,
wires,
yes,
The
Your
property
Lordship.
high tension wires.
Yes, my lord, the property is owned by the government, Commerce and Industry Department, and we both are tenant. So, my lord, he is running his sawmill industry, and I have erected a transmission, my lord. So, my lord, there was an issue that because the transmission, his sawmill has been affected, is the case of the petitioner. Whereas, my lord, my stand is that he has actually constructed beyond the authority of the permission of the landlord, my lord, that's the government. So, my lord, and moreover, my lord, he was actually intimidated not to make the construction, which he has made the construction. So that is in small, my lord. In short, that is the case of the entire. However, we both are, my lord, we can say we are tenant, my lord. We are not the sole owner of the property. The property is owned by district and Industry and Commerce Department, my lord.
So this
Even so, to the limited rights that you have.
yes. The issue is very limited, Your Lordship. Whereas in the last occasion, okay, before filing these two additional things to bring into record, who started the inception of the unit? Whether is that the power line has come before, whether the unit started before or the construction started before. That is the issue. I have already filed my.
But if it is a matter, if it's a question of a dispute of facts, then can this court go into that?
No, my lord.
No, the inception, because the court was asking what is the inception of that unit. Okay. I already filed my things, details out here.
And your lordship has pointed that was only a blueprint, my lord.
Yes, that is also.
It's a blueprint, my lord. So how far can this court accept that blueprint is the actual document which says he has actually come into the possession of the property? Whereas I have clearly stated documents is also brought by me in 2017. I've already erected the transmission, my lord.
Lordship, even I have the same issues of the same documents I have, which I've already submitted in the form of affidavit. For that blueprint, the type copy. As already mentioned in the things.
Okay, let's have a look at it and see who has, acknowledged the
yes, Lordship, that is,
whether it is on official record or
yes,
so on and so forth. Let's have a look at that. Please start.
So, case of the petitioner is like, in a nutshell, Your Lordship, that he possesses this property, this land is taken from the government in pursuance to the Supreme Court order dated. This in pursuance to the Supreme Court order dated, because the unit was previously in the Meemantadu in different place. After the direction of the Honorable Supreme Court, the government has directed to shift the property to the present location. Okay, and with the following conditions, whatever it is existing before. So same has been shifted. The land was allotted and the construction was done. Thereafter, and for that, Your Lordship, can you come to? I just filed an affidavit in this regard. I just bring to record. Additional affidavit. The additional affidavit.
Go from the beginning. Who are you?
I am the.
What is the matter about?
I am the owner of the sawmill.
So there is a sawmill.
There is a sawmill, and the sawmill has come into existence in that particular at the present place after the direction of the Supreme Court to move from the previous area to this industrial.
So your sawmill was previously located at Meemantadu.
Meemantadu.
Then by order of the Supreme Court, it was shifted to where is this place? Claythursi.
Claythursi, industrial state. So thereafter, I have been shifted it. The land is allotted. I constructed according to the things, and because apart from the mill, I need certain other spaces also for my staffs, for my laborers, and everything. So the same has been constructed. So thereafter, the Protocol 4 and 5 has come to erect that power line. So we objected for that, and in that pursuant to that also, in my petition also, I have already mentioned in my petition, Your Lordship, the annexure number 4, annexure 4, page 18.
Page 18.
18. Annexure 4. A4.
4 or 6?
4.
Page 18 here is 6.
No, that is the amended one, Your Lordship.
Oh, amended.
Amended, yes. My Lordship.
Yes.
That is written by the Director of Commerce and Industry to the Executive Engineer, Joy Distribution Division, MPDSL, shifting of 33 kV and 11 kV line at the industrial state Claythursi. While referring to your letter cited above, I am to reiterate that the so and so kV lines which passes through the Claythursi industrial state in general and the industrial unit of MS Bislina or Pasa Sawmill, that is the petitioners, convenient in particular, were constructed without obtaining prior permission from the department. The department is saying that you have erected that post, it is without the prior permission of the department. As such, it is incumbent upon the corporation to shift the line at its own cost. Question of payment by this department or the unit does not arise. Okay. Lordship, in the same, in pursuant to this, that is Annexure 8, that is page 23. This is again written by the Director of Commerce and Industry. Annexure 8, page 23. Same thing to the Executive Engineer. Kindly to refer to report of joint survey of the shifting so and so. They have done the joint survey also. So estate was constructed so and so at Industrial Secretary constructed on 13/3/27 jointly by HS Law, AE and Sri Reading JE2 and Sri P Toy, General Manager of DC IC Joy, and Sri G Limdo, Assistant Director of Cottage Industry Joy, wherein the inter alia had termed the construction of the building, here's your lordship, MS Bisle Warpasa Camp Vineyard Mill within the industrial estate as illegal and also recommended for shifting of the line. Whereas my learned friend has just mentioned just now that it has been inspected and found that it is illegal. But whereas the department itself who issued the certificates to run the such business is already saying that they have no authority to declare any such building construction as illegal. On pursuit of the report and available documents, it is found that the MECL had not obtained, here also in the same case, had not obtained the NOC permission from this department for the construction of the KV line passing through the Kritichi industry area. Joint inspection team is not the competent authority to declare any building or construction as legal or illegal. In view of the facts and reports by the team is therefore not acceptable. The MECL who has trespassed, your lordship, the trespass to the property of the petitioner into the land should shift the line to a safe place, and providing right way and expenses required therefore for shifting of the line is the sole responsibility of the MECL, being the service provider. It may also be noted that the service provider will be answerable for any untoward incident. You have to be noted, that is a sawmill is posing great danger, not just to that sawmill, even the nearby sawmill also. And the condition of the Malanifan is that their line has come before where construction has started later. That I can prove it here also. I have the thing. So thereafter, we have written several communications. They have denied the things. Then we written to the department also. They also not. They said look into the matters. So ultimately, we have come before this honorable court. Okay, to give us because this is my business. I am running from here. I have the bank liabilities. So many liabilities are there. And that sawmill now is not running because the running also is very limited because no laborers is willing to come because that line is so nearby to the building. Is that said no, we cannot work in such conditions. So right from 2017, we written a long time back. 2017 we filed the matters going on. In 2000 we filed this petition. And as far as the concern is that who started first. In this case, I've already filed two affidavits. The affidavit dated 23rd August 2022. There is a type copy here.
So this is the affidavit dated 23rd?
23rd of August 2022.
Yes.
Yes. Your lordship, from this blueprint, you can see right side in the below.
Yes,
that has been designed by the junior engineer PWD road.
This additional.
Additional affidavit by the petitioner to bring on record the type copy of the annexure A1 of the petition petition. Because that was not readable. So.
Oh, you filed two affidavits on the same date.
I filed two affidavit. That is because your lordship in the petition that the copy of the things is not readable. So I just brought the type copy. That is the annexure A1. This is annexure A1 of the rejoinder in my rejoinder. That is the annexure A1 of my rejoinder of the respondent number 2 and 3.
Type copy of annexure A1.
A1 of the rejoinder affidavit of the respondent number 2 and 3. Because they have submitted one.
Yes.
In the below right hand side, you can see clearly. The blueprint was designed by the junior engineer PWD Road, Urban Subdivision UI, countersigned by the on 4/5/2007 by the Deputy Manager Technical Meghalaya Industrial Development.
Yes.
The industry who give me the permission, who give me the license to run the things, they have countersigned the thing. That means my plan is approved. Thereafter, I started my construction. And as far as Your Lordship, that the what do you call this lease deed is concerned, I'll come to the lease deed, Your Lordship. That is on the affidavit of respondent number 2 and 3.
Respondent number?
Yeah, that is page number 7, respondent number 2 and 3, affidavit.
Affidavit dated?
Dated. Date is 9 July 2019 of the respondent 2 and 3.
This is 10 here. Here is
page 7, Your Lordship.
There's some more.
First para. I just read the relevant
This
portion.
is the lease deed.
Lease deed, yes. The first para in the middle.
Just a moment.
Which is boldly written for the term.
Just a moment. Yes.
Yes. We must look from the page 6, Your Honor. Page 6.
From page 6?
Page 6. Because that is the starting of the lease deed. That has been executed on 17 September 2012.
Yes.
And in the next page, Your Lordship, in page 7,
yes,
in the middle of the paragraph is written for term of 30 years commencing from the 25th April 2007. That means, Your Lordship, after the execution of, that is will commencing on the 25th April 2007. But is executed on 2012. But the terms and conditions will be in person to the 2007.
Okay.
25th April 2007.
So this lease deed?
Yeah, the lease deed was lease deed is 17 September 2012.
Yes, but effective from?
Effective from 25th April 2017. 7, sorry, Lordship. And thereafter, Your Lordship, in pursuance in the terms and condition which is laid down in the sale side lease deed, I have executed this blueprint, which is countersigned by the so and so the authority.
You were already in the in that place since 2007.
No, actually, no, not 2000. Yeah, I'll just come because that is detailed in the another affidavit. I'll have to come to in that. What I'm saying, what I'm trying to say is that the executed on 12 September, and it is effective from the 25th April 2017, and thereafter, just after a few days, on the 4/5/2007, I have cleared my document, that is my blueprint, from the concerned authority, who's given the permission, because that the deed which is executed by the parties, I have to take the permission from them. for construction, any sheds or anything. It is clearly written in the conditions. So I have taken accordingly. 17th of April, 17th of September 2012. 17th of September was executed, and commencing, that means 2007, 25th April. So 25th April 2007 and 4th May 2007, I have taken my permission of all my documents and blueprints.
So on 5th May?
5th May 2007, I have verified my documents.
Taken possession?
Yes, already in possession for construction and buildings and all. So this blueprint has been verified, countersigned by the Deputy General Manager for the Industrial Development Corporation. And Lordship, now the affidavit, which is the commencing of my units, is filed in the same date of 23rd. That is 23rd August of 2022.
Yes. So?
Yeah, that is the additional affidavit to bring on record certain document to ascertain the inception of the unit of the petitioner.
Yes.
I just read the paragraph. The petitioner unit was initially functioning from the area Meemintudu, then Jaintia district, now West Jaintia district, Meghalaya, from the year 1994, Your Lordship.
Yes.
Then in the next paragraph, thereafter on 999, the respondent number 2 issued a letter to the petitioner for proposal of allotment of land at the industrial estate, West Jaintia district, and directed to apply for the provisional residence certificate from respondent number 3. That is annexure B1.
Yes.
Okay. In the para 4, Your Lordship, may I read, sir?
Yes.
The white letter dated 2/11/1990, the respondent number 3 has issued a provisional residence certificate for setting up the SSI unit. That is in annexure B2. May I come to Your Lordship?
Yes.
And para 5, Your Lordship. Thereafter, the provisional forest officer, territorial, Jaintia distribution, Joy, white letter dated so and so, white order dated 7/6/2004, issued a letter to the petitioner for shifting of the sawmill from the Meemintudu to industrial state in view of the direction of the Honorable Supreme Court. That is annexure B3. Yeah, para 6. The white letter dated 8/11/2005, Division Forest Officer Territory Jaintia issued a letter to the petitioner asking to do a needful for a grant of license. So here I've been asked to, after shifting, they said that you apply for the license. So accordingly. In para 7, thereafter submitting all required documents and the license fee, the Principal Chief Observator of Forest and Meghalaya, Shillong, on 12/6/2006, has issued a license to the petition to run the unit in the industrial area. That means my unit is actually officially on recording and say that it is writing from 2006. Prior to that, it was all the communications. So that means we can say that the day it is issued on 12/6/2006, the license, I've been the operator in the industrial area. So that is the document, the fact that I have. Since when my unit was inception, how it has been shifted after obtaining all the necessary documents and the permissions from the government. Then thereafter, Your Lordship, the moment it is shifted, because in the Meemintudu I already had my shades and all. So I have to dismantle or whatever, I have to left over this thing because I have no option because of the direction of the Supreme Court. So on pursuant to that, I shifted to the land which is allotted to me. So thereafter the construction started. So when this in 2006 and the commencing on the April 2007, the execution of that lease deed. Okay. So in the lease deed, it is for the 30 years. Okay, but it is executed on the September 2017. Sorry, Your Lordship, in 2012. So they are, on the basis of those lease agreement, I have executed all the documents and necessary permission I have taken. So thereafter, the respondent number 4 and 5 has come into my place without asking any permissions or getting any authority from the any concerned office department. They have erected, which has been objected by the department itself, which is on the record. So now they are saying that we have been running before, then thereafter these people have started construction. We have constructed, that is, we have a proof. And as far as the concern is in their reply, Your Lordship, my charges on the annexion number 4, annexion number 6, and annexion number 8, none of them they have these answers. They have not replied anything on this. They just kept silence on that. Because that is the main 3 issues. The 3 letters which you issued, in every letter they are saying that your entire process was illegal without obtaining any necessary permissions. So thereafter, the issued one in their affidavit, they have changed the stand. In one point of time, they are saying that your entire exercise of the respondent 4 is illegal. But in their affidavit, they brought another account, say that we are withdrawing that objection they have submitted. At one point, they are having a cold, and at one point, they are having a hot. At one point, they are saying the entire process is illegal. Now they are saying that no, they are taking the necessary permission. If they are taking the necessary permission, what is the procedure they have followed? What documents they have brought before this court? So nothing has been. And election number 4 of my petition, 4, 6, and 8, they are totally silent. They have no reply on that. So my humble submission that there may be directed to shift that thing's property, the line from there, because it's causing this danger. I am not running a business at all. My business totally it's on the closer, and I have a lot of liabilities. The banks is eating my hands. Even the auctions of my property has been initiated. The legal notices are coming up for repaying the loan debts which I obtained for my business. And after having all these liabilities and everything, and these matters are pending for so long, and we've been pursuing the things also with the concerned department, even to the MEC also. And apart from that, instead of removing by themselves, they are asking the petitioner that you pay, will withdraw, will shift the thing. First, they have encroached to my land. Secondly, they have necessarily no permissions given. I have all the permissions, but still I've been denied my right, and my livelihood is affected. So what is my humble submission and my humble prayer is that they may be directed to shift the things and to pay me the compensation. Since that, they have erected into the line into my property, and since when I have suffered in the business. That is my humble submission.
May it please your Lordship. My Lord, so far as my friend's argument is concerned with regard to the lease agreement or how the property has been occupied to either of the party, whether him or me, my Lord. In my affidavit at annexion number 1, my Lord, with regard to the erection of transmission, it is a very clear letter which I have intimated to the concerned department on 22nd May 2007. There is no dispute. I have started the construction soon.
Your affidavit dated?
My Lord, affidavit, this is an affidavit in opposition, my Lord. It was filed somewhere in the month of December 2018, my Lord. As per my office record, it's written 13th of December 2018.
You are respondent number?
I'm respondent number 3 and 5, my Lord. 4 and 5.
4 and 5.
4 and 5.
Yes, affidavit dated.
So, my Lord, affidavit 13 December 2018.
Yes.
So, my Lord, at annexion number 1, my Lord, there is no, this is very much on record when I have erected the transmission, my Lord. Intimation will be on 22nd of May 2007. So, my Lord, we will be starting the construction, my Lord. This is the content of the letter. And so, my Lord, it was very much constructed in the month of May 2007, my Lord.
Erection of the
transmission, my Lord, high transmission
HT. HT line.
HT line, my Lord. That is number 1, my Lord. And number 2, my Lord. So far as my friend's submission is concerned, he has made a submission that he has entered the property. We also in 2007, based on the documents which he has filed in the affidavit, my Lord, and the additional affidavit. My Lord, these are the documents which has to be answered by the other respondent, my Lord, because the communication between them. So how far these documents are authentic? Because, my Lord, I say these documents are just a plan, a draft, my Lord, because a blueprint can take time to be approved, my Lord. So just a countersign may not be necessary. It has been approved. There has to be office, my Lord, communications in which they have approved. And thereafter, my Lord, time will be there in which they will be actually such as the letter which I've enclosed, my lord, intimation that construction will be starting, which he has not produced any. And my lord, so far as the lease agreement, my lord, if the lease, whether the authenticity of the lease agreement, that also my senior colleague can only satisfy how far it is correct. Because, my lord, a lease agreement is executed, my lord, in the future, and the effect is on the past, my lord. How can that far can be accepted, my lord? So, my lord, there's another thing. And, my lord, so far as the lease agreement, considering for a moment that that is authentic, my lord, the entire clause are correct also. My lord, in the year 2019, my lord, this is an issue not pertaining to the lease agreement or the occupancy of the property. This with regard to the extra construction or the additional construction which the petitioner has made, my lord. So far as coming with the project or the entire, my lord, sawmill, there is no issue, I can say that. But the entire issue started once they have made the extra construction. And the petitioner has been issued letter by the landlord, my lord, the authority concerned not to do the construction because it will affect the transmission of the MBCL. To this effect, my lord, I have a letter, my lord. This letter is actually a communication between the petitioner and the respondent, my colleague, my lord, here, which they have intimated not to do the construction. But they have vehemently constructed, and thereafter, my lord, they have come to the Honorable Court saying that his business have been affected. My lord, I do not have the copy, my lord. This has been given one copy from your lordship wants to produce, my lord. He was intimate not to do the construction. It was an illegal construction.
It is not within your official.
My lord, this is my only copy, my lord. And so far as the lease agreement also, my lord, it says the lease agreement also yet to be approved. This letter also has been clearly intimated to him, the petitioner, my lord. So this has been written by the Director of Commerce, my lord. And his construction also, my lord, he has not taken approval for the extra building construction, which has actually affected down the transmission, my lord. This letter has also not been produced, having conceived from this Honorable Court, my lord.
This is the afterthought, Your Lordship.
No, my lord, this
application
has been filed in 2018. And during the procedure of the matter, my lord, the department has filed affidavit subsequently. And these are the documents which has come into record, my lord. So these cannot be afterthought. These are all written record, my lord. Your lordship permits, my lord can have a look on this letter, my lord.
If anything such case, they should have given me this intimation before.
This is a letter written to him, my lord.
Yes, whatever. But
Written
the
to
thing
him,
is
not
that
to
after the petitioner has filed this petition, this letter has come up.
Because my lord, this letter has not been sent to me. Neither
So
copy was served. But once this,
how do you introduce that in court?
My lord, this is a letter which they can authenticate. They can authenticate. They can take instruction, my lord.
Either they produce
because
it.
I have been given this letter by department.
Only if a copy has been given to you.
Yes, my lord.
If that copy has been given to you, then rather a copy has been marked to you, then you can introduce that in court.
My lord, yes.
But this is a communication which is not supposed to be in your possession.
My lord, correct. Because, my lord, after the entire matter was taken up by this Honorable Court, we have also spoken to the department like what has gone wrong, how far are we illegal occupant in the particular plot. So, my lord, we have been informed that we are not illegal. The petitioner has been illegally making the construction. So, to that effect, they have shown us this letter, and to which it satisfies us, my lord, that we are not illegal.
That at this stage, that becomes a new pleading.
No, my lord, this is a letter very much at the very instance of the affidavit of wisdom when it was filed. Maybe, my lord, this was never brought into record, but I have this in my record way back, my lord.
What you can do, Ms. Koni, is, of course, that is for you to devise ways and means of how to bring it before this court.
My lord, if I may pray, the best person is if my senior can, because there's a letter sent by him. He can take instruction on this with the letter and then the authenticity of the letter. And my lord, so far as all the documents which he is relying upon, those blueprint which I'm objecting to, my lord, and even the lease agreement, my lord, which is very inappropriate, my lord, because the content of the lease being not appropriate also, it's been reflected in this particular letter. My senior, for both sides, the interest of both parties, my lord, my senior can take.
Why you have not brought those?
It is their document itself. By the respondent. This list, it was filed with the respondent number 2 and 3. And now
is there in
yes, in their position, in their record. And now my learner friend is saying that it is objected. How can these things?
In record, whose record?
On 2 and 3 record, these agreements.
So they have filed those documents with their affidavit?
No, yes. They have not filed.
Yes, in the record, in the affidavit.
Just check.
This document is not in my possession. So,
not your possession.
The court, I can produce this record by the affidavit.
But now you're saying it's in there.
The list deed is
no, not the list deed.
This document is not in the record.
This is part of my affidavit list deed.
No, what my learned friend is saying that because she has some objections, okay, or some doubts with the lease date, and the lease date has been filed by the 2 and 3.
That is okay. That is okay. As far as the lease date is concerned,
But let them bring on record you.
but if this particular document is supposed to be taken cognizance of by this court, it has come by in a proper way.
My lordship is correct.
You are to bring this on record, Mr. Ram.
My lord, this letter will be proper if my senior bring into record because he will be
the
in
document is in your possession, then you have to do it. You have a copy of this.
I have the copy. Even we have replied to the department also because we have
Then you have to file a rejoinder to that.
No, because there is nothing on record, so I cannot file the rejoinder.
No, that's what I said.
After.
Yes.
Yes, lordship. Yes. They definitely will bring on that.
You could have done that.
And may be allowed to file by way of affidavit.
That's what I said.
This was not my position earlier.
Heard Mr. Barwa, letter counsel to the petitioner. In reply, Mr. Arkunli, letter counsel for the respondent 4 and 5, has submitted to a certain extent, but has, however, referred to certain documents or communication which they are not supposed to be in possession of, but which according to the General Counsel is material to the issues raised by the parties herein. At this juncture, Mr. H. Abraham, letter GA, has submitted at the bar that since the said documents or communication pertains to the department concerned, represented by the department concerned, it is submitted that the same will be allowed to be brought on record by way of an additional affidavit. Though it is a bit too late in the day to introduce new facts to the case, however, in the interest of justice, however, ends of justice, the prayer made by the LNG is allowed that the such document be introduced by way of an additional affidavit with advance copy to be issued upon the petitioner and all the parties involved, to which the petitioner, if so advised, may file a rejoinder, to which the petitioner or the other respondents, if so advised, may file a rejoinder to the state. Mr. Abraham, you prepare the affidavit, give him an advance copy, let him go through and file a rejoinder, so that we don't have to wait for.
And Lordship, another thing, if the respondent 4 and 4 have any doubt regarding my affidavit, which is the documents which I have filed in my additional affidavit, being on record the inception of my unit, let her find the opposition.
Madam, I have not doubted, madam. I have said it is an issue entirely regarding to illegal construction, not about who entered the property, my lord. So far as I am concerned, my lord, I have very clearly stated I have entered in May 2007. My friend has not been able, he is relying on blueprints, certain countersign, my lord. Countersign can be the person who has prepared it. A genuine officer has to prepare it, my lord. It does not mean that based on the countersign, my lord, the property, the entire structure has come up. So, my lord, he has to still satisfy whether and when he has actually started the construction.
Will,
So that is a different issue, my lord.
we will hear the matter on that.
If this is the case, Your Lordship, see in that case, she's saying that my entire construction is illegal. Whether she
Not
has the
entire, my
no,
lord.
whatever,
The additional
my additional
construction.
construction. Then whether the respondent forum have the authority to say before this court submission.
My lord, I'm not saying the letter which my custodian has to take instruction.
That
That letter says, my lord.
Why respondent forum respond?
A show cause. This is a letter which it's a show cause notice, my lord.
Let them give a submission.
My lord.
Let
So
them present their
Yes,
case.
so
Let them present their case.
We'll look whether you see whether you are entitled to such line of submission.
My lord, I have brought this because the department has conveyed us. So, in my defense, my lord, I have to bring that because I was given this letter also.
Okay, we'll file a rejoinder on that.
This is matter after 2 weeks. 2 weeks.
Oblige you.
Item number 11.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, I humbly pray Your Lordship to withdraw with liberty to file afresh, Your Lordship.
What is this matter about?
It's regarding appointment, Your Lordship.
Two years down the line, and now you're saying you would want to withdraw it?
So far as withdrawal is concerned, my lord,
Yes.
I'm okay, my lord. They seek to challenge my appointment in this case, my lord.
Okay. School matter.
School matters.
School matter.
Appointment of teachers.
Withdrawal is fine, my lord. With the liberty, my lord, I will have a difficulty. I would object to it. As it is, my lord, in this case, they have nothing much to place it before your lordship, my lord.
What is this case about?
This is an appointment of science teacher, my lord. Assistant teacher in some deficit school. Now, what happened, my lord? There was an interview held, and as per the advertisement, my lord, the mode of communication regarding the schedule of the interview was through message, which was duly done to all the candidates. It's not their case, my lord, that they were discriminated in any way. Messages were sent to all the candidates. Now, what they are saying is, my lord, he received a message a day prior to the interview, wherein he was in Calcutta. Now, there's no document annexed that he was in Calcutta at the given point of time. He missed the interview. He missed the interview, my lord. The interview was carried out on a scheduled date, and the respondent number 6 and 7, whom I am representing, my lord, they were duly appointed. And it is not their case, my lord, that the petitioner was better positioned than me. In fact, my lord, there won't be a question of better position
that is a different matter. That will come later.
Correct. He did not even appear in the matter. He's missed the bus completely, man.
What matters is, if his contention is that because of the message being received at a late hour, put it that way, for which he is inconvenienced, then certain accommodation has to be made, number one. If he can prove that he was elsewhere.
Yes. In fact, there's no document to show that he was elsewhere that day. The second thing, my lord, is even though he says that he was there on the other day, I mean on the date on which the interview was scheduled, and he reached there and he was not given any audience, even though he says that, he files the application, the objection, after about 4 to 5 days before the Deputy Commissioner. Now, my lord, his lordship is aware, recently also the Honorable Apex Court has passed an order. My lord, this gentleman 6 and 7, my lord, so far as their appointment is concerned, there is no irregularity, there is no arbitrariness. There's no illegality at such. That is one aspect. My lord, here they have been teaching already for the past 3 years. Now unseating them, at this stage, when there is no illegality per se with their appointment, my lord, would be not only, my lord, against the law, my lord, it will be a travesty of justice insofar as 6 and 7 is concerned. That's why I say, my lord, they are free to withdraw, my lord. But so far as liberty is concerned, that is something which is...
What is your ground for withdrawal?
I don't have the instruction, Your Lordship, because as my senior is in DB, Your Lordship. So I just have the instruction to withdraw with liberty to file afresh, Your Lordship.
If it is a case of improvement by bringing some of the material which they failed to bring it,
there's no question of liberty given. You see, number one, this is a written.
Correct.
And you know very well, there's no issue of limitation as far as it is concerned.
Correct, correct.
You can file at any point of time. Perhaps the issue of res judicata may be.
If their rights survive, they can still come. There's no question of liberty.
Yes. Liberty would be given only if there are some technical defect. Then
that's why if they say that the right still survives on the given set of facts and circumstances, they can still come.
I think you can do that. So
in this matter, then let my senior appear, Your Lordship, because I don't have any instruction regarding.
You don't want to put your neck on the block. On primary petitioner, this is matter to 1 week.
All right.
Item number 12.
Good. Yes. What is this matter about?
No, this is relating to school, my lord. 4 writ petitioners are there, who are the teachers, my lord. Their basic grievance was against the private respondent number 7, my lord, for wrongly, my lord, forming an ad hoc committee. Of course, that period was expired, my lord. And subsequently, what had happened, my lord, the draw and disbursement authority was taken over by him illegally, my lord. Now, we have made a prayer before this honorable court, my lord. Subsequently, there was an order passed by the government whereby the draw and disbursement authority has been given to me. I am the petition number 1 and the head teacher of the school, my lord. So as far as that aspect is concerned, it is okay, my lord. Now, what had happened, my lord, during the process when the private respondent number 7 was possessing the power of the draw and disbursement authority, my lord, there are several amounts which has been taken by him, my lord, which he is not entitled to. And as a result, what happened, my lord, some of our salaries are still pending. Now, as far as the private respondent number 7 is concerned, my lord, he has never appeared before this honorable court. The ex parte order is already been passed. Whether a copy was served on him or not, my lord, we have also filed an affidavit stating.
Who is the respondent number 7?
My lord, it is
the person who had supposedly embezzled the money.
Yes, my lord. This private respondent number 7. This is, my lord, his name is, my lord, Abdus Samad Sheikh. So our main grievance at this juncture is against private respondent number 7, my lord. Now, admittedly, my lord, he has never appeared. Copy was served on him. Thereafter, my lord, this honorable court was pleased to, my lord, issue an order of ex parte order was issued against the private respondent number 7, my lord. And most importantly, my lord, we are the sanctioned teachers. The private respondent number 7 is not a sanctioned teacher. He is the junior most teacher. My lord, what had happened?
What is your case and what is your prayer here?
So our prayer is, my lord, our prayer is several folds, my lord. Firstly, if I take, my lord, to page 20 of the writ petition, my lord.
Yes.
So, my lord, the first part is quashing of the impugned letters, whereby, my lord, the draw and disbursement authority is given to the private respondent number 7.
This has been settled.
This is settled, my lord. Secondly, point number 2 is also settled, my lord. Direct the concerned notification respondent.
You have been given the DDO power.
Yes, my lord. So this is also settled. But however, my lord, the other money which is taken by him, that remains unsettled, my lord.
That would be
direct the private respondent number 7.
Have you filed an FIR in that regard? You should have done so.
My lord, FIR would not file because at that point he was having the draw and disbursement power. But however, my lord, in the table we have given in a very detailed manner. If my lord kindly allows me to go through the table which is at, my lord.
If the allegation is for misappropriation or embezzlement or.
But most importantly, my lord, the respondent number has not disputed. Respondent number 7 has neither appeared before this honorable court, neither disputed the fact, my lord. That's the most important part.
But okay, let's hypothetically
My lord.
put it this way. Can this court, in the event that your prayer succeeds, can it direct the respondent 7 to hand over, whatever the money or everything to you?
This court may direct, my lord.
I doubt.
This court may direct, because this is pertaining to, now this salary is also already, the government has already sanctioned the amount. It is lying with someone else. Someone else has misused this, my lord. If I kindly take my lord
What
to...
is the amount involved? How much is the amount involved?
My lord...
6,87,280 as page 12 of page 20.
He is still teaching the school?
Yes, he is the junior master. He is holding a non-sanctioned post. My lord, I kindly take my lord to para 4. If I am allowed to read para 4, my lord.
Yes.
And then because it is enclosed to... That the petitioners herein are the founding members of the said Popular Government Aid UP School Gandhimari, and has worked very hard and run the said school since its inception in the year 1997.
You are reading?
My lord, para 4 from page 10 onwards, my lord. 10 of the writ petition.
So, okay, let's put it this way. The state respondent, you have anything in this matter?
State respondent, we have already completed the prayer made by the writ petitioner
So
on
1 and 2.
Yes, sir. 2 will be important, because 2,
now because
the moment that order is out, then the other order goes naturally, my lord. Because when the draw and disbursement order is given in my favor, so naturally the other order goes, my lord.
And the respondent 7 chooses not to contest that.
Yes, my lord.
He has been intimated.
Yes, my lord. We have filed affidavit of service. Also, we have filed.
No, as far as the charge of DDO being taken from him and handed over to you.
Yes, he has not contested.
Not contested.
Not contested, my lord.
So in the absence of pleadings.
Lord, our pleadings are very specific.
No, yours is.
Yes.
But
he's not contested, my lord, because he knows his flaw. In fact, my lord, the private respondent number 7 had earlier approached this honorable court by way of a writ petition, my lord, stating that he is a sanctioned teacher. Now, thereafter, my lord, this matter was heard. The honorable court came to a finding that he is not a sanctioned teacher. Even the government, both the state as well as the managing committee, has contested the case, and thereafter, my lord, after hearing all the parties, the honorable court came to a conclusion that he is not a sanctioned teacher. Now, in spite of all that, my lord, during the period of lockdown, behind the back, he constituted an ad hoc committee. Then he ended up, my lord, gaining the authority of the draw and disbursement by misleading the officials. And then that is the period, my lord, whatever salary came. In fact, I being the first teacher, my lord, the head teacher, I did not get salary for a period of 18 months, not a single amount, my lord. Now this I have clearly, very categorically stated in my writ petition, my lord. So if I am just for my lord,
what you can do, Mr. Prasadi, then
because the respondent number 7 is clear that he knows that he cannot defend this. That is exactly why he has not appeared before this honorable court, my lord.
Okay. So you start relating your case in a systematic manner.
My lord. So my lord, what had happened, my lord, is that
yes,
there are 4 writ petitioners before this honorable court, my lord. who are holding the sanction post, my lord.
First, state your status, state your.
My lord, I am the petitioner number, now,
You are, who are you?
I am the petitioner number 1. In fact, 1 to 4 are all.
Yes, you are a petitioner.
We are the teachers, my lord.
Teachers of what?
Teachers of this popular government aid UP school, Gandhimari, my
You
lord.
see so.
Yes.
Yes.
My lord, we are the founder teachers. The school was, my lord, the school started in the year 1997, my lord.
Okay.
And my lord, subsequently in the year 2000 onwards, my lord, the school started receiving government aid, my lord.
Okay.
So initially the government aid was around, say, 70 for 6 teachers, 4 teachers, my lord, 6,000 each they used to get, my lord, some lump sum grant.
Okay.
Now presently, my lord, the school is getting a grant of, as in at the point when the writ petition was filed, my lord, that time it was, the school was getting a grant of 66,000 per month, my lord. So these are for the sanctioned teachers. Now what had happened, so my lord, the teachers were getting their salary as it is. Now what had happened, my lord, the main problem had arisen, my lord, when during the, my lord, period of the COVID, my lord, an ad hoc committee was formed by the private respondent number 7, stating that he is the head teacher, whereas the actual head teacher was not involved in the meeting. A meeting was convened, ad hoc committee was formed. Then in the meantime, my lord, he had taken sanction from the government with regard to the draw and disbursement. This is where the problem started, my lord. Now this, the private respondent number 7 had been creating problems before also, my lord. First is that initially, my lord, white WPC number, earlier he had filed a writ petition, my lord, stating that he is a sanctioned teacher. Now as I have stated, my lord, that matter was decided by this honorable court and there was a clear finding that he is not, my lord. So, my lord, the moment he took over the managing committee, my lord, that is when the petitioners started facing problem with regard to their salaries. Now they have written several representations to the department. Now as the department, my lord, did not resolve the matter, my lord, so the petitioners were compelled to approach this honorable court, my lord. So during the, now what was the prayer, my lord, when they approached this honorable court, is that three were main, my lord. First is this, the power disbursement order which was issued by the government in favor of private respondent number 7 should be done away with, my lord. Subsequently that was done. Second prayer that we had prayed for is that the authority should give draw and disbursement authority to petitioner number 1 being the head teacher. That was also done, my lord. Third prayer was for us is that it may direct, this honorable court may direct the private respondent number 7 to refund whatever money which he has drawn in excess, my lord, to which he is not entitled. This is the third prayer before this honorable court, my lord. So third prayer, fourth prayer is also the same, my lord. And so basically the case revolves around the salary, my lord, at this juncture. Otherwise it is for a fact that we are the founder teachers. We are still, as on date, we are still serving in the said school. Now, my lord, as far as the salaries are concerned, my lord, after this draw and disbursement order is issued, so the current salaries, we are not facing any problem, my lord. Where we are facing problem is the earlier round, when the draw and disbursement authority was with the private respondent number 7. So at this juncture, my lord, that is the main issue that we have. If I am allowed to read para 4 of the writ petition, my lord, it will be very clear.
Please.
I'm allowed to start from para 3, my lord. Para 3 is at page 9.
Yes.
That the petitioner number 1 is the headmaster of Popular Government Aid UP School, Gandhimari, West Garo Hills District, Meghalaya, and the petitioners number 2, 3 and 4 are the assistant teachers of the said school and were duly appointed in the year 1997. So this is the appointment order, my lord. The 4 petitioners herein are the senior most founder teachers and are holding 4 sanctioned posts in the said school. Normally, most of the grant-in-aid schools have only sanctioned teachers, but however, a decision was taken by the school managing committee to employ 2 extra teachers holding 2 non-sanctioned posts, and accordingly, 2 persons were appointed: Shri Noor Hussain Khondoker and Shri Abdul Samad Sheikh. So this is the person, my lord, of which Shri Abdul Samad Sheikh is the junior most non-sanctioned teacher of the said school. The petitioners herein, that's para 4, my lord.
Yes.
The petitioners herein are the founding members of the said Popular Government Aid UP School, Gandhimari, and has worked very hard to run the said school since its inception in the year 1997. Subsequently, in the year 2000, the aforesaid school started receiving government grant in form of grant-in-aid to the tune of rupees 6,000 per month in the initial years. At present, the school is getting a grant of rupees 66,000 per month, that is 7,92,000 per annum. Again, as per normal procedure, the sanctioned teachers are supposed to get their salaries as per government notification sanctions issued from time to time by the Education Department. The latest of which was issued via memo so and so dated 29/6/2017. So that is Annexure 2 of the writ petition, my lord. The petitioners herein fall within the list of 459 teachers, being sanctioned teachers of the said Popular Government Aid UP School, Gandhimari, but unfortunately...
So there are 459 teachers in the school?
Oh, my lord. This is the list of teachers in the... as per the list of teachers of the Government of Meghalaya, my lord, of the aided schools. So their list is also, their names are also included in the list, my lord. That is what it says. Being the sanctioned teachers of the said Popular Government Aid UP School, Gandhimari, but unfortunately they have not been receiving their due salaries as per the government grant sanction, owing to the fact that a portion of their salaries are being used to pay the salaries of the other 2 extra non-sanctioned teachers. Factually, the salary of the other 2 teachers ought to have been arranged by the school managing committee of Popular Government Aid School, it should have been school, my lord, out of its own private funds, if any, and the due salaries of the petitioners as per government sanction from time to time ought not to have been interfered with, as the same is against all norms and procedures. So, my lord, what had happened is that even from the sanction amount, my lord, certain amount is to be taken away by the managing committee to pay the salary of the other teachers. Whereas actually, my lord, whatever is my sanction, I should be given that amount, my lord. Now, I am asked to shell out a certain amount of money so as the private teachers can be paid. So that cannot be the case, my lord. In the instant case, the junior most teacher, Shri Abdul Samad Sheikh, who is occupying the non-sanctioned post of the said Popular Government Aided UP School Gandhimari, has illegally taken control of the school, including the power to draw and disburse salary, and is thereafter using the government grants to his full advantage. He also manipulated the school fund and deprived the petitioners of their lawful dues as per the notification of the government dated 29/6/2017, in so much so that the petitioner number 1 was not paid a penny of his salary dues with effect from 1/9/2019 till date, and the same has caused immense hardship to the petitioner. With regard to the petitioners number 2 to 4, it may be stated that their salaries have not been paid as per their dues with effect from 1/9/2019 to 28/2/2021, and from the month of March 21 no salaries have been forthcoming till date. Whereas based on the RTI informations, it is found that Sri Abdul Samad Sheikh, respondent number 7, has been drawing more than his dues with effect from 1/9/2019. This is where the problem starts, my lord. For proper understanding of expenditure, financial irregularities by respondent number 7, this Honorable Court may kindly refer to the table which is provided here under. So this is the table, my lord.
Yes.
Now, my lord, particulars of salary. So petitioner number 1, 2, 3, 4, my lord, is given. So what is the amount actually due, my lord? My lord will kindly see. As a head teacher, I am getting 18,000. The other 3 petitioners are getting 16,000 per month, my lord. So total amount which is due is 3,24,000 in the third column, my lord,
Yes.
of serial number 1. Now, my lord will kindly see amount paid. Here it is blank. No amount has been paid. So total due for me is 3,24,000. Here also, my lord, respondent number 2, apologies, my lord, petitioner number 2, the total salary which is due to me is 2,88,000. Amount, whereas my lord, amount paid is 1,86,000.
Yes, so that is true.
Writ petitioner number 2, my lord.
All these others have got their
My lord, the others, the 2, 3, 4, they have got some amount, my lord, not a complete amount. How much is the payment due?
Yes.
Petitioner number 2 received 1,86,000, whereas actual amount is 2,88,000. So therefore, the due amount is 1,02,000.
So about 1 lakh. This
Yes.
okay. So
Yes.
amount is-
So here similarly, my lord, petitioner number 3 was only paid 1,38,000 out of a due of 2,88,000, and total due is 1,50,000, which still remains unpaid, my lord. Then petitioner number 4, again she has been paid 1,76,720. The amount which remains due is 1,11,280, my lord. So the total amounts unpaid to the petitioners by the private respondent number 7 is, my lord, 6,87,280 till 28/2/2021. And my lord, this is another table. My lord, this is another table regarding the extra teachers, my lord, just for clear understanding, my lord. So here the Noor Hussain, he's the substitute teacher, my lord. He's the next junior teacher at fifth number, my lord. He's the 5th teacher.
Okay.
So his salary is 9,030 per month, my lord. So total is, my lord, which he is entitled, total amount in annually he is entitled is 1,62,540, my lord.
Okay.
Amount which is paid in excess is, my lord, 1,77,000. So amount paid in excess is 14,460. Now this is the private respondent number 7, my lord.
Okay.
He is entitled to 9,020 per month. So for 18 months he is entitled to 1,62,360.
So this number 2 is respondent 7.
Yes, my lord.
Yes.
So he is actually entitled to 1,62,360, my lord. This is I am calculating for 18 months, my lord, because since I am claiming the 18 months period. And how much he has paid, my lord, how much has gone into his account is 5,57,000. So he has drawn more than 3,94,640, my lord. So similarly, my lord, as this is the third post is the Chokidar. Here also, my lord, excess amount has been paid, which is 22,200, my lord.
Yes.
So now next page, my lord, this will be very clear. This is at page 14, my lord.
Yes.
Interestingly, the respondent number 7, Sheikh Abdul Samad Sheikh, at one point of time had approached this Honorable Court via WPC number 357 of 2017, claiming that he is a sanctioned teacher, but the same was vehemently contested by the respondent therein, which includes the state respondents. After hearing the parties, this Honorable Court was pleased to dispose the same by order dated 1/8/2019, Annexure 3 of the writ petition with an observation. Well, the observation is, my lord, it says that after hearing the learned counsel for the parties, especially the concessions made by the learned counsel for the petitioner, this writ petition is accordingly disposed of with the direction that the petitioner be paid a salary as fixed by the managing committee by various resolutions and stands currently at 9,020 regularly, and further that he be allowed to withdraw the arrears salary is due. But my lord, this the petitioner did not agree. This the petitioner has not agreed, my lord. However, after the said order of the
petitioner or the respondent?
Sorry, apologies, my lord. The respondent, he was the petitioner there, my lord. However, after the said order of this Honorable Court, Shri Abdul Samad Sheikh refused to accept the amount of rupees 9,020 on the ground that the same is not acceptable to him. He informed the managing committee that he would not accept any salary below the amount of rupees 16,000 per month, to which he is not legally entitled. This only goes to show the conduct of the private respondent number 7, my lord. So this is number 5 is reiterating the point which I was stating before this Honorable Court, that, my lord, behind the back the petitioners formed an ad hoc managing committee. So this is where, my lord, he got a draw and disbursement order in his favor, due to which he took this full advantage. So, my lord, my humble prayer at this juncture is that, my lord, this Honorable Court can direct, my lord. This is a writ proceeding, my lord, and it can definitely direct this private respondent number 7 to refund, my lord. My lord will kindly see, look at his conduct, my lord. He is never bothered to appear before this Honorable Court because he is fully aware. Because, my lord, as per his earlier order also, this, in fact, my lord, what the writ petitioner has, as in the private respondent number 7 has done is that, my lord, he circumvented the order of this Honorable Court in the earlier writ petition, where there is a clear finding that he is not a sanctioned teacher. Now this is a clear defiance of the Honorable Court's order, my lord. When there is an order which is already against you, you defy, you manipulate the authorities, you form an ad hoc committee, you take the charge of draw and disbursement order. On what basis? Who are you? That also you are the junior most teacher. Then you embezzle the funds. My lord, we have also stated another allegation, my lord.
Have you made the managing committee a party here?
Yes, managing committee is a party, my lord.
Who's appearing for managing committee?
Managing committee, as per the lordship order dated 3rd June 2022, there was no managing committee. Previous managing committee has dissolved. So we have given a direction to constitute a managing committee. So whether the managing committee has been constituted or not, that is not within my knowledge. Because there was an order dated, if I'm pleased to take your lordship to my affidavit filed by respondent number 6. Affidavit filed by respondent number 6, your lordship. Page 7, Annexure 1. I'm pleased to read that order. With reference to the
see, Mr. Prasadji,
my lord,
at the relevant point of time,
my lord,
there was a managing committee.
My lord, my apologies, I stand corrected, my lord. When the writ petition was filed, my lord, there was no managing committee in existence. However, my lord, the private respondent number 7, draw and disbursement authority, he is using the power.
Have you made an averment to that effect?
Yes, my lord.
There was no managing committee.
My lord, the ad hoc, we have made an averment with regard to ad hoc, my lord. My lord, this is at para 5. Para 5. In fact, my lord, in our prayer also we have stated that there should be a managing committee. My lord, that prayer 8 of our writ petition, we have clearly stated, my lord, which is at page 22. and further may allow the petitioner number 1 herein to take necessary steps as per rules and procedure provisions to constitute a new managing committee.
You see, in any school,
My lord.
the importance and the role of the managing committee is paramount.
Yes.
Because the managing committee will control each and every aspect of the administration of the school.
Yes.
Including, appointment of teachers, disbursement of fees,
Yes.
disbursement of salary, and so on and so forth.
No, my lord. Normally, in absence of a managing committee, my lord.
In the absence of managing committee, the government would appoint somebody, any officer, to take that role.
No, normally either it is this head teacher or the principal, my lord.
That would have then he would have been approved, should have been approved by the government.
Yes, he is approved, my lord. That is why draw and disbursement authority is given to the head teacher.
So now, at the relevant point of time, it would seem that the respondent number 7 is
no, my lord. Respondent number 7 cannot form a managing committee at all, because in any formation, the head teacher will have to be taken into account.
Yes, of course.
The headmaster of the school. The headmaster of the school was never taken into account. He is behind the bag.
But why is there no managing committee then?
Exactly, my lord.
What happened to since the inception of the school? There was no.
No, there was, my lord. There was, my lord. There was at that point of time, even prior to, my lord, the ad hoc managing committee. There was a managing committee in existence, which had subsequently, my lord. In the meantime, this ad hoc committee came into existence. And the term of the earlier managing committee had also expired, my lord. Now thereafter, due to COVID and all, my lord, there was no as such public meeting and all that for the formation of the managing committee.
So see, now if you say there's an ad hoc managing committee.
No, that term has also expired, my lord. That ad hoc managing committee was only for a certain period, my lord. It is clearly written.
Okay, now
with
that
effect from 10/10/2019 to 10/1/2020.
So another either a regular or an ad hoc managing committee should have been formed in the meantime.
Exactly, my lord. Exactly.
And who's to take initiative for that?
Your Lordship, to that we have given the direction as per Annexure 1 of my affidavit at page 7. If I am pleased to take Your Lordship. Affidavit filed by respondent number 6, Your Lordship. Page 7, Annexure 1. The last paragraph.
Annexure.
Page 7, last page of my affidavit. Last page of my affidavit. Filed by respondent number 6.
Yes.
This letter was issued on 3rd June 2022. Then if I'm pleased to come to that second para. In the meantime, the convener ex officio member is directed to convene general meeting of parents and guardians to reconstitute SMC of the school. School managing committee we have given direction to constitute.
Who is the ex officio member?
That is supposed to be the newly the Cinemas teacher.
Cinemas teacher, man. The petitioner number 1.
Petitioner number 1. So whether the managing committee has been constituted or not, I have no information, Your Lordship.
This is so as recent as 3rd June 2022.
Yeah, 2022.
But
yes.
the course of
By
action.
now, the managing committee might have been constituted.
My lord, that information, of course, I do not have. I will also have to consult, my lord.
It doesn't see even whether your prayer or your petition is valid or not has to be looked in in the light of whether there is a managing committee.
Yes,
what would be the role of managing? What would be your first course of action? It should have been to approach the managing committee. To rectify these.
There was that point of time. There was no managing committee in existence.
So, if there is no managing committee, then you would surely have to approach the government.
Yes, that is what we have done, my lord.
So, have you done that? Is there any?
Yes, it is clearly given. We have our representation is there, my lord.
Yes, so that representation is there.
Yes, representation is there to SDACO.
Where is it?
My lord, it is at Annexure 5, my lord. Annexure 5.
Annexure 5.
Yes. My lord, there seems to be some problem with the pagination, my lord. If I am allowed to rectify the pagination.
No, what?
My lord, as per my writ petition, it is Annexure 5B, page 52, my lord.
Page 52.
But I think there is some mistake, my lord. If I am allowed to rectify.
Annexure 5 is page 45. This is a letter dated 21st March 2009.
My lord, page 52, my lord. My lord, that's fine.
Page 52. You're talking about Annexure 5. This is Annexure 5.
5B, my lord.
Just a moment.
5B, page 50.
Yes, 5B is page 50.
Yes.
So this is correct.
Yes, 14 June 2021, my lord.
This is 14 June, yes.
Yes. This is one representation, my lord.
No, this is only for empowering you and formation of fresh MCAs.
An application regarding your kind needful action as regards anomalies in the school affairs of so and so, my lord. Necessary orders empowering, yes. Drawing disbursement, my lord. Now the next page also, my lord. This is for non-receipt of salary, which is Annexure 6, page 54.
Okay, let us first look at this. Again, come back to your Annexure 5B.
Annexure 5B. With due respect.
Yes.
And the subject cited above, I have the honor to lay before you the following few lines for favor of your kind perusal and doing the needful.
Yes, so now tell me, what is the response to this?
No response, my lord. That is exactly why we approach this honorable court.
Mr. Abraham, what is your response to this?
That
government did not respond.
With regard to that, I have no instruction.
This is part of the pleadings.
Whether the government has
in your counter affidavit, you should have responded to
I
this.
have not taken that ground, Your Lordship. Because as per the representation, we allowed it. We have already handed over the draw and disbursement to the petition number 1.
Okay, so
that we have already completed.
Perhaps that would be in response to this letter.
Yes, Your Lordship.
So the first part is done. But as far as the
my lord, this happened when, my lord, only after the writ petition was filed. My lord, in the course of the my lord, on the hearing, then the government took this step.
When was your writ petition filed? On which date?
My lord, our writ petition was filed
2021.
2000. Yes, my lord. It was filed in the month of November 21.
Okay.
So I've communicated that letter on 3rd June 2022.
So this, yes. And this, your representation was 14 June.
My lord, it was filed in the year 2021, my lord, 14 June.
No, yes, that's all. But, so there is no response to this letter?
No.
But it is implied that I have already responded to this letter as per Annexure 1, page 7.
No, that was later. That was in June. In
3rd June, yes.
When that is after 1 year.
When these proceedings are pending.
Already before this honorable court, yes.
Okay. So, but as far as formation of the managing committee, you should have, it's incumbent upon you to have done something.
At that time,
either you say we are not doing it, or wait for some time, we'll do it, or we'll do it. You should have respond in those terms. You have not done it.
They have not acted promptly as per the representation given by the petitioner. But however, we have already complied with the representation filed by the petitioner. Why that was 3rd June 2022? Of course, it was at the deleted stage, but not that we have already complied.
Okay. Let's put it that the facts as it stand is that there is no managing committee.
No.
So what is the step taken by the government to ensure that you have taken over the functions of the managing committee?
Yes, Lordship.
Where is that?
There was no other asset, but since it was temporarily taken over by the subdivisional school education officer, then thereafter we have given the direction to the headmaster to.
When have you taken? When was it taken over? Temporarily.
No, my lord. There is no such order. There is no such order. In fact, as far as the draw and disbursement authority, that is given to the head teacher, who is the that order is not
there.
there.
No specific order, but since there was not the managing committee, the managing committee, the term there that ad hoc managing committee expired. So temporarily we have taken care. We have taken the charge. Then thereafter we have given the authority to the headmaster to constitute the managing committee. That is our stand, Your Lordship. Not that we want to carry on this administration for the school managing committee, but it was because of the compelling circumstances we have to take over this management for the time being. That was interim. Then later on we have given the authority to the headmaster to constitute the managing committee.
No, even the fact that you have taken over, interim, course of action, that is not reflected here.
No, that's not reflected.
It is not reflected. And if that case, then
in fact, my lord, even
I will take instruction.
The school is also entitled for midday meal, my lord. Now, even in the midday meal, my lord, the private respondent number 7 has inflated the amount of students. The amount of student actual was stated in our writ petition. Actual amount of student is 30. The private respondent has inflated the amount to 98, my lord. So there also there is embellishment.
So you see, in all these things, your complaint should have been to the government.
Yes.
And the government, but then the government cannot take action against him if he is not a sanctioned teacher. It is only the managing committee to have taken such action.
That is there, my lord. But nevertheless, the government could not have given the draw and disbursement order.
Could not have.
Yes, my lord.
So he was given a free hand. I don't know why.
If I'm pleased to take your lordship to page 3 of my affidavit filed by respondent number 3, your lordship, respondent number 6.
Page
3, para 6. I have given some para 6, page 3, para 6. If I'm pleased to read, your lordship. That with regard to the amendment made at para 5 and 6 of the writ petition, the answering respondent clarified the matter of fact of the approval of the ad hoc committee of the school is that the petition number 1 had been degraded, ranked down from the post of headmaster, and the respondent number 7, the science teacher of the school, had been assigned the in-charge headmaster by the managing committee. White Managing Committee Resolution number 2 and 3 dated 27 November 2019. However, the respondent had never given approval to that effect. The petition number 1, the headmaster of the school, while in the ranked down position, the tenure of the managing committee had expired, and the in-charge headmaster could not convene a general meeting for constitution of regular managing committee for the school, and the school was facing much problem without SMC. As such, on the representation and recommendation of the well-wishers, village elders and parents, guardian of the school, an ad hoc committee was granted an approval for the greater interest of the smooth running of the school, and with the direction that the ad hoc committee shall convene general meeting for constitution of a regular managing committee. So the allegation against the formation of the ad hoc managing committee is not tenable. Actually, it is there.
Well, where's the authority, or where's the the relevant order for formation of this ad hoc committee?
There is no order, my lord.
The petition number 1 is supposed to be the managing committee was supposed to be constituted by the petition number 1, your lordship. He was then the headmaster, so he is supposed to constitute the managing committee, but it was not.
So this was as far back as 2019.
2019, yes, your lordship.
Where's the letter that you have written to him?
There's no letter, my lord.
But it is
this was found behind.
No, he was. But here you have see. This is your vermin.
Yes, your lord.
Huh? That the petitioner number 1,
headmaster of the school, while in the ranked position, the tenure of the managing committee had expired, and the in-charge headmaster could not convene a general meeting for constitution of regular managing committee for the school, and the school was facing much problem without SMC. As such, on the representation and recommendation of the well-wishers, village elders and parents, guardian of the school, an ad hoc committee was granted an approval for the greater interest of the smooth running of the school.
Granted and approved, not approval.
Granted, yes, Lord.
Approved, mean it has already been approved.
Yeah, granted and approved for the general.
So where is this?
Of the? It is not that.
Where is this
But there is no supporting document.
It has not been annexed, Lordship.
There is no supporting document.
Because we were of the view, because the prior of the petition has been complied, that's why we have just annexed only that letter communication.
That cannot be.
Forward
If
to
that is the case, then the onus would be on him.
Because
he should have convened the meeting and formed the managing committee, at the relevant point of time.
Yeah,
in 2019 or 20.
No, if there is a direction to the ad hoc committee, my lord, I am not a part of the ad hoc committee. How will I form the managing committee?
Because the main prayer of the writ petition is just to release the salary, and for that we have already complied, and we have given the letter, given the power joint disbursement to the petitioner number 1, and we have on top of that we also given the direction to
He says
the
he has
managing committee. So
he has not received anything. You keep saying that you have given him the power.
this was not prior of the part. This was not the case of the petitioner.
So it is your pleading. You have to support your pleading by corresponding authorities.
Because this was never the prior of the petitioner. We just, as part of the prior of the petitioner, we have complained. So that we were of the view that since the prior of the prior of the petition has been complained.
You do one thing, Mr. Aram. You file this by way of an additional affidavit. Whatever relevant information, if you say that you have authorized or rather directed the petitioner number 1 to form the ad hoc managing committee, file that.
The ad hoc committee, we have never given the approval. We have stated in my affidavit.
Who has constituted the ad hoc committee?
The ad hoc committee was considered.
Was it done by the petitioner number 1?
By the private respondent number 7, but we have not given approval.
No, we are not talking about that. We are not talking about that.
My lord, it is approval is there at page 49 of our writ petition, my lord.
Approval of what?
Approval of the ad hoc, and as well as convener to
So,
my lord, we'll see the disbursement orders. Disbursement order is at my lord. My lord, will kindly see page 48 of the writ petition. Who is the ex officio? He has been made the ex officio, my lord. See, Abdul Samad Sheikh,
yes.
convener, ex officio member of Popular so and so, is hereby allowed to draw uniform school grant, midday meal due to expiry of MC till the month of September 2020. Power is given to him, my lord. The order is valid till 30/9/2020. Now, subsequent order is at page 49, my lord. The Sri Abdul Samad Sheikh, in charge, convener, and ex officio member of so and so. Gandhi Mari is entrusted to draw and disburse salary of teachers till the month of December 2020, as the school has no regular managing committee. In the meantime, the in charge convener and ex officio member is directed to convene. So, the direction has gone to whom, my lord will kindly say? Is directed to convene the meeting of parents and guardians to reconstitute a regular school managing committee as per the RTI norms, consisting of senior most teacher as its convener. So direction is given to private respondent number 7.
Yes.
I have never received any direction. This is dated 3rd May 2021.
So your submission and your pleadings are contrary.
But in my affidavit, I have not taken those ground for the reason that we were specifically filed an affidavit to the prior made by the petitioner. Because they are making a prior to allow them to pay the salary. So we have accordingly released the salary. That is the why we have not taken all these details, because we thought that we have already complied as part of the prior made by the petitioner.
Ram, you are a responsible government department.
If I'm pleased to take a look,
you should have every action that you take must be taken, with circumspection, must be taken in accordance with the proper rules and norms. You are very much aware that the respondent 7 is not a sanctioned teacher.
With regard to
in
the
spite
sanction,
of that, you made him a ex officio member. What do you call it?
Ex officio member.
Ex officio member. directed him to convene a managing committee meeting or whatever.
Even, my lord, in Annexure 5A, page 46, my lord will kindly see to whom the amount is transferred.
Well, now with regard to the sanctioned teachers, whether the petitioners are also a sanctioned teacher or not, that was doubtful. They are not, because we have not given approval, because they are only supposed to be only 3 sanctioned teachers, but there are 4 rate petitioners. Who are the sanctioned teachers? Who are not the sanctioned? We are not on. We are not into that, Your Lordship. But because we are just strictly into the prior made by the rate petitioner. For that, we are not disputing whether they are sanctioned teachers or not sanctioned teachers. But only we are more concerned about for releasing the salary. And we have accordingly released. And by giving the power to the rate petitioner number 1, the draw and disbursement. So, and we have already completed that part. That is the reason why we have not taken the detail of those.
We are sanctioned teachers, my lord.
Will not go to
And our table is also very clear. It is very clear from the table, my lord. And we have also stated that our name is included in among the 497 government, ad hoc teachers, my lord.
Your affidavit is not very. We'll resume this hearing after when you check your affidavit and see whatever is required to be corrected or taken step. You do that.
I have to take in my affidavit. I have not taken all those ground, Your Lordship. I have just written a very short affidavit.
The whole picture is not clear.
But my lord, we are sanctioned teachers. That is exactly why this matter was never disputed, my lord.
So we'll hear it after 1 week.
Yes, Your Lordship.
But there are consultative parties. Matters kept part heard. This is here after 1 week.
Item number 13.
Lastly. Okay, you were absent at the
I was stuck in a
you should have informed your colleague too. Or does it will not matter to you. Matter will come up. It's not that it has been dismissed. It will come up.
Yes, Your Lordship.
Order has been passed. On the next date fix, we'll take it up.
Highly obliged, Your Lordship.